Also, in that interview with the New York Times, the president was asked if he would order the Justice Department to reopen the investigation into Hillary Clinton's emails. Here's how the president responded, quote, "I have the absolute right to do what I want to do with the Justice Department, but for purposes of hopefully thinking I'm going to be treated fairly, I've stayed uninvolved with this particular matter." Our legal analyst, Paul Callan, is here. Let's tick through this. So, Paul, he says he has the absolute right to do whatever he wants with the Justice Department. True?
True and false. He is the person in charge of the Justice Department. So, for instance, he could order them to divert resources from one investigation to another or to terminate an investigation. He can do that. However, if the purpose of terminating the investigation is to protect himself or to punish an enemy, that could be viewed as an abuse of power and or an obstruction of justice. So, as I say, it's yes and no, because if he's giving a legitimate order, it has to be followed. But you can also commit an act of criminality in that context.
What's up, folks? Adam is here. So what just happened, guys? One sentence unlocks everything. Asked about the limits of his authority, Trump said he has the right to do whatever he desires as president. Not whatever statute permits, not whatever courts allow, whatever he desires. His constitutional citation, Article 2.
Then I have an Article 2 where I have the right to do whatever I want as president, but I don't even talk about that. It's a thing called Article 2. Nobody ever mentions Article 2.
More importantly, Article 2 allows me to do whatever I want. Article 2 would have allowed me to fire him.
So it sounds
but
like
I wasn't going to fire. You know why? Because I watched Richard Nixon go around firing everybody, and that didn't work out too well. So, very simply, Article 2 would allow me to do.
I could have done anything I wanted. I don't even bring it up because we don't even get there. Absolutely, I have Article 2. It gives me all of these rights at a level that nobody has ever seen before. We don't even talk about Article 2.
That single sentence explains every firing without Senate consultation, every acting official bypassing confirmation, every court order ignored, every deportation without due process, every military deployment without congressional approval, every war launched without legislative blessing. He didn't hide his governing philosophy. He announced it on camera. Article 2, the "whatever I want" clause. And every constitutional confrontation since has been the Republic's answer to that sentence. That is the foundation upon which this entire governing philosophy has been constructed.
All right, Mimi, I went to high school, you went to Harvard. Article 2 of the Constitution, is it A, possible that it was Bill Barr who explained the president's seemingly magical powers as found in Article 2? And what does Article 2 say in a consumer-friendly way?
I mean, Article 2 does lay out the executive powers, and they are broad, but it also has limitations in it. For example, they have to be done in a way you can't do things that are illegal. You have to uphold both the spirit and the actual law, and you can be impeached for, as we all now know the phrase, high crimes and misdemeanors. I think what happened here, and the reason Trump was, saying this, I'm a monarch, essentially, I can do whatever I want, is because Barr and maybe Giuliani at some point explained to him their view of why there's no obstruction in the Mueller report. No, that firing the FBI director and all that, that's okay, because you're allowed to do that. That's an executive power.
It is the constitutional basis for a theory of power that reduces to a simple, terrifying equation. I am the president, and the document you think constrains me actually liberates me to act without limit. And for the better part of the past year and a half, the federal judiciary of the United States has been engaged in a systematic, painstaking, and utterly relentless demolition of that theory. They have been doing it one ruling at a time, one injunction at a time, one sharply worded opinion at a time. The judges are not merely saying, "You're wrong on this technicality." They are invoking Article 2 itself as the instrument of the president's undoing.
Remember, he discovered probably a month into it, he thought that because he was the president of the United States, he couldn't have conflicts of interest. Therefore, he didn't have to divest himself of any of his financial or business holdings.
Who knew healthcare was hard?
Who knew healthcare was hard? Who knew that China had this long and illustrious history? Who knew that Article 2 made you all powerful? He's going to interpret everything he learns on the go as empowering him to do whatever he wants to do. That's not going to be a new phenomenon. The problem we're seeing in all this is that there's no countervailing force. There's no one in the GOP specifically who's saying to him, no, Mr. President, you're demeaning the office. No, Mr. President, you're redefining the office in the wrong direction. And we as a party and we as a country should hold this institution in a different regard.
They are holding up the same constitutional text he claims as a shield and showing him, in precise legal language, that it is actually a cage. A jurist appointed by Ronald Reagan examined the executive order seeking to unilaterally reinterpret the 14th Amendment's guarantee of birthright citizenship and declared it blatantly unconstitutional. Not merely flawed, not requiring further refinement, blatantly, obviously, indefensibly, the highest court in the land, in a case bearing his name against the state of Illinois, refused his demand to seize control of a state's National Guard for domestic enforcement purposes. Judges in multiple jurisdictions have halted executive orders designed to financially cripple law firms for the sin of providing counsel to his adversaries. Courts have stopped spending freezes and the arbitrary termination of grants. They have blocked deportations that skipped the essential step of a fair hearing. By the middle of the previous year, the ledger of judicial rebukes had grown so thick that it told a clear story. Federal judges had found a significant number of major executive actions to be illegal across the sprawling landscape of immigration, military engagement, administrative oversight, and the fundamental tenets of due process. The man who believed Article 2 was a throne is watching that same article be transformed into a gallows for his entire administrative apparatus. Come on, are you kidding me? This is wild. And the complete chronicle of Article 2 versus constitutional reality is one of the most significant accountability narratives of this entire era. Let us be perfectly clear about what Article 2 actually contains, because the gap between the text on the parchment and the interpretation being peddled from the podium is the entire ballgame. Understanding this distinction is not a matter of pedantic legal scholarship. It is the key to diagnosing whether we are witnessing a simple misunderstanding or a deliberate, calculated assault on the separation of powers. Article 2 is, in truth, a remarkably concise and specific piece of drafting. It vests the executive power in a President of the United States. It designates the President as Commander-in-Chief of the Armed Forces. It grants the power to make treaties, provided the Senate offers its advice and consent. It empowers the President to nominate and, with the Senate's advice and consent, appoint ambassadors, judges, and other officers of the government. And it contains the clause that is so frequently overlooked but so fundamentally important. The President shall take care that the laws be faithfully executed. That is the architecture of Article 2. Faithfully executed, not selectively executed based on political convenience, not executed when the mood strikes. Faithfully, every single law. That includes the laws the President finds inconvenient, the ones that slow him down, the ones that require him to justify his actions. It includes the Administrative Procedure Act, which mandates that agencies follow specific notice and comment protocols. It includes the carefully interpreted limits of the Alien Enemies Act. It includes the War Powers statutes that Congress enacted to reclaim its constitutional prerogatives. It includes the binding nature of court orders issued by judges under the authority of Article 3. Article 2 does not contain a secret passage that says, or just do whatever. It grants executive power, command authority, diplomatic and appointment powers, and the solemn duty of faithful execution. It is a broad grant, yes, but it is a bounded grant. And that word bounded is the operative concept because every constitutional provision that allocates power to one branch carries within it an implicit limit on that power. And it is those limits that judges are now enforcing with increasing vigor. When they cite Article 2 against this administration, they are not rewriting the Constitution. They are reading it aloud. They are saying, this is what the document actually says. And nowhere in this text is there a blank check. Begin with the assault on birthright citizenship, because it produced the most viscerally damning judicial language of this entire saga. The President issued an executive order seeking to terminate the automatic grant of citizenship to children born on American soil to parents who lack permanent legal status. The 14th Amendment to the Constitution is explicit on this point. Section 1 states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. The language is not ambiguous. It is not a suggestion. It is a constitutional command that has been interpreted consistently for well over a century to mean exactly what it says. If you are born here, you are a citizen, regardless of the paperwork in your parents' filing cabinet. The executive order asserted that the president's Article 2 powers granted him the unilateral authority to reinterpret this bedrock constitutional guarantee through the stroke of a pen. And then a judge who was placed on the federal bench by a Republican president who was no shrinking violet when it came to claims of executive authority, looked at that order and used the phrase blatantly unconstitutional. That word, blatantly, is carrying a lot of weight. It is the judicial equivalent of a slap in the face. It means this is not a close question. It is not an innovative legal theory awaiting validation. It is a president attempting to use an inferior instrument, an executive order, to nullify a superior law, a constitutional amendment. That is not a sophisticated Article 2 claim. It is a fundamental category error regarding the hierarchy of legal authority, and a Reagan appointee said so, using those exact devastating words. The targeting of law firms adds an entirely new, darker dimension to this story. The executive branch issued orders specifically naming prominent law firms, Jenner and Block and WilmerHale among the most visible targets, for retribution. Their crime was not malpractice or fraud. Their crime was having represented clients who had the audacity to sue the administration or who had affiliations with political opposition. The orders directed federal agencies to strip these firms of security clearances, to terminate existing government contracts, and to physically bar their attorneys from entering federal buildings. The legal justification, such as it was, rested on the theory that Article 2 vests the president with absolute discretion over who the executive branch does business with and who is permitted access to its facilities. Therefore, the argument went, he can use that discretion as a cudgel to punish lawyers for taking cases he finds objectionable. Federal judges intervened to block these orders, and the reasoning behind those blocks is essential to understanding the stakes. The orders were found to violate the First Amendment's explicit protection of the right to petition the courts and engage in legal advocacy. They were found to violate the Fifth Amendment's guarantee of due process, as the firms were being punished without any opportunity to be heard or defend themselves. And most importantly for this discussion, they were found to exceed the proper scope of Article 2. The courts recognized that this was not an exercise of managerial discretion. This was the weaponization of executive authority to chill the very mechanism that makes judicial review possible. Because if the president can functionally destroy any law firm that dares to challenge him, the ability of ordinary citizens, businesses, and advocacy groups to use the courts as a check on executive power evaporates. The judges saw the play for what it was. It was an attempt to use the facade of Article 2 authority to make it impossible for anyone to effectively challenge Article 2 overreach. And they said no. The Supreme Court's intervention in the Illinois National Guard dispute warrants particularly close examination because it carries the ultimate weight of judicial authority. The court denied the president's bid to federalize the Illinois National Guard for the purpose of suppressing domestic protests. The specifics of that situation have been covered in detail elsewhere, but the Supreme Court's action in Trump versus Illinois established a crucial precedent from the highest possible bench. It affirmed the principle that the commander-in-chief powers embedded in Article 2 do not extend to the unilateral federalization of state military forces for domestic law enforcement purposes, particularly over the explicit objection of the state government and absent the satisfaction of specific statutory criteria. This ruling, when combined with the tariff decision covered previously, where Chief Justice Roberts wrote that the president was claiming a blank check over global commerce that Article 2 simply does not support, begins to form a coherent Supreme Court jurisprudence on the limits of executive power. The court that this president believed he had built in his own image is now the institution that is drawing the most authoritative and indelible lines around what Article 2 actually permits. Those lines are, without exception, significantly narrower than the whatever I want doctrine. Let us drill down into the legal scholarship of Article 2 to understand why this judicial pushback is so constitutionally sound. The phrase, "the executive power shall be vested in a president," has long been understood to include certain inherent powers that flow from the nature of the executive function itself. The president can direct the operations of the executive branch. He can issue pardons. He can negotiate international agreements. He can exercise command over the military. These are substantial and significant powers. But no serious scholar, not even the most ardent proponent of the unitary executive theory, has ever suggested these powers are limitless. The Take Care Clause is the textual anchor for this limitation. The president must take care that the laws be faithfully executed. That clause is not just a grant of authority, it is a duty and a restriction. The president does not get to pick and choose which laws to follow. He must follow the Administrative Procedure Act. He must follow the Immigration and Nationality Act. He must follow the War Powers Resolution. He must follow the statutes governing the National Guard. He must follow the International Emergency Economic Powers Act as properly interpreted, not as creatively imagined. The Take Care Clause means that the executive branch is subordinate to the legislative branch in the realm of lawmaking. When nearly two-thirds of the hundreds of legal challenges filed against second-term executive actions cite violations of the Administrative Procedure Act, they are making a Take Care Clause argument. They are saying, you are required by law to follow these procedures. The Constitution commands you to follow the law. You are not following the law. And judge after judge, across the ideological spectrum, is agreeing. The rulings on the spending freeze and the termination of grants illuminate how this overreach infects the entire administrative state, not just the Oval Office. When the administration froze billions in congressionally appropriated funds and terminated grants in ways that violated the Impoundment Control Act and other statutory frameworks, the entire machinery of government became complicit. The Department of Homeland Security, the Department of Justice, the Department of Defense, and countless grant-making sub-agencies were all implementing illegal directives. The injunctions issued by the courts did not just name the president personally, they bound the agencies and the officials who run them. The entire apparatus of federal administration, the departments and agencies that actually deliver services and enforce regulations, found itself entangled in a growing web of court orders declaring specific actions illegal and mandating specific corrective measures. This is what it means when we say the entire administration faces action. The government itself, in its operational capacity, is under judicial supervision, and the career officials and political appointees who staff those agencies are increasingly trapped between their professional and legal obligation to obey court orders and the political pressure to follow presidential directives that those same court orders have deemed unlawful. Consider the record being compiled by civil liberties organizations and tracked by major news outlets. By the midpoint of the previous year, the litigation tracker showed a pattern of judicial rulings finding executive actions to be illegal across a vast range of subjects. Hundreds of cases. Emergency motions flooding multiple circuits, a scale of litigation with little precedent in the modern era. This volume is not an accident. It is the direct foreseeable consequence of a governing strategy that relies almost exclusively on executive orders and emergency declarations, bypassing the slow, deliberative process of legislation and administrative rulemaking. When you govern this way, you create a litigation magnet on every single initiative. The Administrative Procedure Act gives affected parties the right to challenge agency actions that skip required procedures. And when roughly two-thirds of the challenges against this administration specifically allege APA violations, it confirms that the chosen method of governance, fast, unilateral action without legislative input or proper administrative process, is systematically generating legal vulnerability across the entire policy portfolio. The law firm targeting is the most revealing piece of this puzzle because it exposes the ultimate objective. The firms were targeted not for what they did, but for who they represented. They represented the people and organizations who were using the courts to challenge the administration. Therefore, the executive orders were an attempt to use Article 2 authority to dismantle the legal mechanism by which Article 2 overreach is most effectively checked. The courts, the lawsuit, the competent counsel. If you can punish the lawyers who take cases against you so severely that lawyers across the country start calculating the risk and deciding it is not worth it, you have effectively disabled judicial review without ever having to argue in court that judicial review does not exist. It is a backdoor route to the whatever I want destination. By making the exercise of constitutional rights financially and professionally ruinous for the attorneys who enable it, you achieve functional immunity from the rule of law. The judges who blocked these orders understood the assignment. They were not merely protecting the balance sheets of a few white shoe law firms. They were protecting the constitutional structure of the United States. They were ensuring that Article 3, the judicial article, remains a co-equal branch of government. There is a profound and poetic irony threading through all of this. The president has invoked Article 2 to justify nearly every aggressive action of his second term. Tariffs, National Guard deployments, citizenship reinterpretation, punishment of legal adversaries, spending freezes, deportation flights. Every single power grab is wrapped in the flag of Article 2, and the courts, including the Supreme Court he helped to populate, are using Article 2 as the very tool to explain why those actions fail. The Reagan-appointed judge invoked the Constitution's structure to call the Citizenship order blatantly unconstitutional. Chief Justice Roberts invoked the constitutional allocation of the taxing and commerce powers to Congress to reject the tariff theory. The Supreme Court invoked the limits of the Commander-in-Chief Clause to deny the Illinois Guard federalization. The judges blocking the law firm orders invoked the constitutional structure of an independent judiciary to prevent the executive from disabling judicial review. In every single instance, the response to the president's Article 2 claim is an Article 2 counter-argument. The courts are not saying, "We wish you wouldn't do that." They are saying, "The document you swore to preserve, protect, and defend does not authorize that action." And that is why the Article 2 fight is the foundational accountability battle of this era. It is a fight over the meaning of the document itself, and the courts are answering that question with a consistency that makes the whatever I want theory legally unsustainable. Let's distill this into the specific actionable takeaways that define where we stand. The characterization of the birthright citizenship order as blatantly unconstitutional by a Reagan appointee is the single most politically significant judicial statement in this entire fight. It cannot be dismissed as the work of a liberal activist. It comes from within the conservative legal tradition. It uses the most unambiguous language available to the judiciary. Blatantly means obvious to anyone who can read. When a judge of that pedigree uses that word to describe an executive order, he is making a statement about the order's fundamental incompatibility with the constitutional order. That is the kind of cross-ideological condemnation that is hardest for political allies to spin and most damaging in competitive electoral environments. Second, the fact that roughly 2/3 of the legal challenges are built around Administrative Procedure Act violation signals a systemic, self-inflicted wound. This is not about one bad legal memo. This is about a governing method that treats procedural requirements as optional suggestions rather than binding law. When the dominant legal challenge across hundreds of cases is, "You didn't follow the rules for making rules," the problem is the method itself. Governing by fast-moving executive order generates APA violations by design, and APA violations generate injunctions, and those injunctions, if ignored, generate contempt proceedings. The Article 2 crises are downstream from this fundamental choice to bypass the legislative and administrative process. The law firm targeting orders represent the most constitutionally alarming overreach because they were designed to decapitate the legal opposition. Using executive power to punish lawyers for taking cases against the executive is using executive power to destroy the mechanism of judicial review. The judges who blocked those orders were not just ruling on a contract dispute. They were defending the existence of an independent bar, which is a prerequisite for an independent judiciary. Fourth, The accumulation of hundreds of adverse rulings is building a permanent, documented institutional record of systematic executive overreach. Each ruling is a data point. Each injunction is a finding of fact and law. Each blatantly unconstitutional label is a judicial assessment. Together, they construct a comprehensive, legally verified dossier of an administration that has been systematically claiming powers it does not possess. This record is available to future Congresses considering legislation, to future prosecutors considering charges, to historians writing the first draft of this era, and to voters heading into the next election cycle who are trying to separate fact from fiction. The Article 2 fight is not just about specific policies. It is about establishing the documented constitutional character of this presidency. Here is the bottom line. The president said Article 2 gives him the right to do whatever he wants. A Reagan judge said his signature immigration order was blatantly unconstitutional. The Supreme Court said he could not unilaterally seize control of a state's National Guard. The Chief Justice said he was claiming a blank check over global trade that the Constitution does not honor. Multiple judges blocked his attempt to financially cripple law firms for representing his opponents. Hundreds of legal challenges have found that his agencies violated the procedures required by law. The entire administrative apparatus of the federal government is now operating under a growing cloud of court orders finding specific actions illegal. Article 2 does not say whatever the president wants. It says executive power with specific enumerated authorities and an unyielding obligation to faithfully execute all the laws. And courts across this country, from Reagan appointees to the Chief Justice of the United States Supreme Court, are telling this administration what Article 2 actually means. They are doing it in rulings that are building the most comprehensive judicial record of presidential constitutional overreach in modern American history. He wanted Article 2 to be a crown. The courts are using Article 2 as a measuring stick. And by that measure, the administration is coming up short time and time again. Stay tuned. The next Article 2 ruling is already making its way through the appellate pipeline. And based on the trajectory we have witnessed, the answer from the judiciary is going to be the same answer it has been delivering for months. No. The Constitution does not permit what you are claiming. And here is the specific provision that says so.